All right. I know people are still signing in and joining us, but since we only have 60 minutes, we're going to go ahead and get started. Welcome to everybody to Miller and Chevalier's webinar, Lessons for Exporters from Keysight Technologies and Other DDTC Itar Consent Agreements. I am Brian Fleming. You can go ahead and move it forward, Mariana. I am happy today to be joined by our brand new colleague, Chris Stagg, who just joined us at Miller and Chevalier a couple of weeks ago. Very fortunate timing, shortly on the heels of the Keysight Technologies consent agreement. And we're thrilled to have Chris on board as part of our export controls and sanctions team at Miller and Chevalier. And we're really excited about, obviously, his deep expertise with respect to all things DDTC and export controls, and you'll be hearing from him in a moment. And we felt like for those who are perhaps less familiar with this area and with DDTC enforcement in general, we felt like this was a great opportunity, given that we only get about 2 of these a year on average, to really dig deep on the latest consent agreement that just came out, obviously from DDTC a couple of or early in August, and to put that into some broader context with other recent consent agreements, and even beyond that, as you'll see as the discussion moves along today, even more broadly, just in terms of the way that U.S. export controls, and in particular ITAR enforcement and compliance, have been developing and have been administered kind of across the agencies. So we're gonna bring sort of a broader focus as well, just beyond what DTC is doing as we sort of walk through the presentation today. You can move us forward, Mariana. So to quickly run down what we're proposing to cover today, and I should also add that we are very welcoming of all of your questions. There's obviously a Q&A function, a chat function. You can send in any questions in writing. We will be keeping an eye on that. We'll try to potentially deal with those as we go, and if not, hopefully we'll have a few minutes at the tail end of the hour to address those. And if we do not, we are happy to connect with you offline to discuss any questions that may be sort of on your mind or prompted by the presentation. So we're going to proceed with, we're going to start with sort of a general overview of DDTC enforcement. We're going to then move on to get into some details about the recent Keysight Technologies consent agreement. And we'll sort of recap that for you for those who maybe haven't had a chance to review the papers in detail. And we're going to sort of share some thoughts and some insights that we have on the recent consent agreement. And then we're going to pivot to sort of the most recent tranche of consent agreements going back a few years from DDTC to kind of look for some patterns, some trends, and to really analyze kind of some thematic threads that we see that have been kind of appearing recently and sort of reappearing in some of these cases over time. So we will spend quite a bit of time on that, trying to really contextualize, and then we will move on to some more practical compliance considerations for those of you out there who are sitting in your respective companies having to deal with these issues on a day-to-day basis. The folks that we're typically talking to help navigate these challenges, which can be quite complex. And in particular, the last bullet there, the special situations, I think those are some particularly complex situations that come up when the government perhaps intervenes in a particular matter or expresses interest in a particular matter, or multiple agencies are involved in investigating or reviewing a particular matter, how to sort of navigate those, and some things to be keeping in mind as you go through that. So without further delay, let's go ahead and move the slide forward, and then I will turn it to Chris to get us started.
All right. Well, before moving into all the nuances of the latest consent agreement and all the other consent agreements, just wanted to provide a basic overview for how a case can move forward from inception, the receipt of information of a potential ITAR violation, all the way through to a consent agreement. And the process starts with the State Department receiving information about a potential ITAR violation. The most frequent way that they obtain that information is through a voluntary disclosure that they receive, where a company might uncover a potential ITAR violation or even an actual ITAR violation, and they want to disclose that for various reasons to the US government. That's the primary way that the government receives information on these potential violations, but there are also other mechanisms in place where they can receive the information from other government agencies. If the Justice Department is involved in a criminal investigation, or there's a criminal proceeding that's taking place in one of the federal district courts, that information can move over to DDTC. Information from Customs and Border Protection, information from Homeland Security investigations, the FBI, the Department of Defense, Department of Commerce, Department of Treasury. The State Department has a Blue Lantern program where they go out and do end use checks, and they get information from that source, and they can uncover potential violations that way as well. And also from just people calling the State Department and reporting potential violations on other companies, individuals within companies, and so forth. So when they receive this information, they first will do an initial analysis of what they have received. And this is different depending upon the circumstance. If they receive a voluntary disclosure, usually there's an initial voluntary disclosure where they just announce that we've generally uncovered certain potential violations. Now we're going to go investigate, and we'll do a full disclosure in a few months. In those cases, usually the State Department will wait for that full disclosure to come in, and then they'll start to evaluate the case. In the circumstance where they have a lot of incomplete information, where it's just pieces of information that might come from another government agency, there will probably be more of a further investigation of trying to obtain more information within government sources before letting a target know that they are under investigation. So in that process, the government might try to determine whether or not to proceed with a further investigation based on the data that it has. For a voluntary disclosure, it will look at the information, say, okay, well, we think we have enough. We have a complete profile here, and our focus is on other voluntary or directed disclosures. So we're going to focus our resources there, and we'll just go ahead and issue a no action letter. Or there's the situation in either case where it is a government investigation or just solely from a voluntary disclosure, where the government will assess whether or not they need additional information or further action needs to be taken. So if you have provided a full voluntary disclosure and there's still issues there about whether or not there could be additional violations or whether or not some proposed corrective actions are really going to work, they can direct an audit, they can direct a combined jurisdiction request, they can ask for additional information from the company as well. The ITAR has numerous record keeping requirements, so they can proceed with asking for records, and this request by itself can uncover additional violations if there are certain records that need to be kept under the ITAR and they can't be disclosed to the government, or they can't be revealed to the government because the records are just not there. So that's the process that the government will take as part of its review of a potential violation. And then from there, it will also be an assessment of whether to proceed with still closing out the case, even if they have directed audits and so forth, or to proceed with a penalty agreement or an oversight agreement or a full consent agreement, which we will discuss over the next few slides. During this process, when there is a disclosure, a lot of companies will already go ahead and start taking corrective actions. They have disclosed the matter to the government, or the government has identified the issue, and to better seek a closeout of the issue, to show cooperation and that you understand the consequences of ITAR violations or potential ITAR violations in the future, to just go ahead and try to do some corrective actions to fix the problem, and hopefully that satisfies the regulators as well. So where there are corrective actions that have been taken place before there's any closeout of an enforcement matter, that also will weigh on the regulator's mind in terms of, well, they've been cooperating with us. We feel like they've done exactly what we've needed them to do. So maybe we should focus on another case for a consent agreement rather than this specific situation. So that's, broadly speaking, the review process that the government takes from inception of a potential violation all the way through to either close out or all the way to a consent agreement. And as Brian had mentioned, there's only about 2 consent agreements a year. So a lot of enforcement actually takes place privately between the State Department and companies, where again, they are subject to a disclosure case and either they resolve the issue there or it's just closed out. So it never becomes public like a consent agreement. Next slide, please. So just briefly of the structure of what a consent agreement is, it comprises of 3 documents: the proposed charging letter, which describes the nature of the violations, what happened, how many violations there were, what the aggravating and mitigating factors were that DDTC considered. And that is a document that can also be negotiated in terms of the language that is used there, and also the focus of what specific violations that the government is going to pursue. Then there's the consent agreement, which provides the terms and conditions of the consent order, which provides whether there's going to be a special compliance officer that's going to be required, the term of the consent agreement, which is usually around 3 years. Some have been 2 years, some have been 4 years. Whatever the remedial measures are going to be, whether there's going to be a jurisdiction classification review, revising policies and procedures, doing an audit, and so forth. Any penalty that's going to be involved. Usually in a full consent agreement, there is going to be a penalty. And then whether or not there's going to be any debarment. Next slide, please. So for the most recent consent agreement with Keysight Technologies, the issue there was that the company makes certain types of software, and one such software that they make is called a multi-emitter scenario generation software. And it's software that works with test sets involving electronic warfare. And on the US munitions list, there's an entry, category 11A11, for certain test sets that are specially designed for various articles, which include articles involved in electronic warfare systems and equipment. And they had reviewed this item internally within Keysight Technologies, and they determined that based on their review, it's subject to the EAR, not subject to the Itar, and with a classification of EAR 99, which is the lowest export classification you can get under the EAR. In 2017, the State Department, through its policy office, which is responsible for administrating and overseeing the US munitions list and the commodity jurisdiction procedure, they reached out to Keysight Technologies and they disputed the classification and felt that it should be reviewed under a commodity jurisdiction request because it might be ITAR controlled. Several months later, Keysight submitted the CJ request, but they still continued to treat the software as EAR 99 while that CJ case was pending. And this included additional exports to the People's Republic of China, which, as it was then, as it is today, is a prescribed destination under the ITAR with a presumption of licensing denial, and to Russia, which at the time was subject to restrictive export controls under the ITAR, so a license probably would not have been obtainable, and now Russia is a proscribed country as well. So they continued the exports, and they also made a version of the software that I believe was still ITAR controlled, as at least it's described in the proposed charging letter, available on its website for download by the public. In April of 2018, the State Department came back and they determined that this software, through their interagency review process, is ITAR controlled software because it is software that is directly related to a defense article. The controls here on the US munitions list for software in this context is a catch-all control for technical data, which includes software, that is directly related to a defense article, and the defense article in this case would be the test sets that are specially designed for electronic warfare equipment. So after the CJ determination, Keysight does now treat the software as Itar controlled, and it does take it down from its website. After that, they do submit a disclosure to DDTC regarding the previous exports, including those under the combined jurisdiction request. After they have completed their full disclosure to the State Department, they do try to appeal the original combined jurisdiction request or the determination, and DDTC reaffirms their original decision that the software is ITAR controlled. And then in August of this year, it's publicized the consent agreement with Keysight for the unlicensed exports caused by its misclassification, including those while the CJ request was pending. So although we're going to get into a couple of interesting angles of this consent agreement, fundamentally, this consent agreement involves an issue that DDTC has repeatedly hammered on in consent agreements, which are the natural consequences that arise through a misclassification. So here, there would not have been an issue if the item came back as EAR control, because there would not have been ITAR violations, even with the exports to China and Russia. So it all came together with the fact that there was this misclassification. And two examples of other consent agreements where DDTC is really focused on this issue is the 2014 consent agreement with Intercell and the 2013 consent agreement with Aeroflex. Next slide, please.
And I think to build on Chris's point, it does all, at the end of the day, boil down to the misclassification, the self-classification that was found through the CJ process to be inaccurate. But I think it is important to remember, and I think this consent agreement in particular underscores this point, that every case is to be taken on its own, and every case is going to be very fact dependent in terms of what the ultimate outcome is going to be, whether we're even in consent agreement territory or not. And looking at some of the aggravating and mitigating factors, I think, is particularly illuminating on that point. Top of the list here with regard to aggregating factors, and this is a point we're going to come back to a few more times in the presentation, is the determination by DDTC that there was harm to U.S. national security, and in particular the fact that that determination was made in connection with the fact that there were exports to China and Russia. It was not just the sheer fact that these misclassified tech data and software had been exported 24 different times. It was the fact that over half of those were to China and Russia, both prescribed countries, obviously China, a long time arms embargo imposed there. So I think it is very important to sort of bear that in mind, and we'll be coming back to that point, I think, a few more times today. The second point there on the aggregating factors, what I think is interesting, is these are violations that were initially discovered by the government itself. This is not a voluntary disclosure case. We don't have full detail as to precisely how the government uncovered this potential misclassification issue and what prompted it to bring that issue to the company's attention. There are many different ways, as Chris noted before, there are many different ways that information could have come to DDTC's attention. We don't precisely know because it's not detailed in the charging letter, but that is significant, and obviously, depending upon how that does come to the government's attention, I think can certainly impact the way it's going to be viewed, even from an early stage, whether it's coming from a whistleblower, a competitor, through another government agency, through a news article, all kinds of ways that we've seen over the years that these things can come to the attention. So that's another thing to bear in mind. And as you may be evaluating these things yourself, thinking about how the government has learned of something, or how you want them to learn about something if a voluntary disclosure is potentially on the table. And then the third point, which is I think the big one here, and probably is at the end of the day, along with the China issue and the Russia issue, what tipped this into consent agreement territory, is that the company continued to treat the technical data and software as subject to the EAR, and during the pendency of the CJ, even after the government had alerted them to the fact that they thought that that this may be misclassified and may in fact be on the USML. So I think it's an interesting kind of thought exercise to say, well, if the company had just put the pause on any exports during the few months between the submission of their CJ and the result of the CJ that came about 3 months later, would the government have would they have ended up with a consent agreement for any of the historical violations, even if the result was the exact same? If they had not sort of taken that position and sort of continued to say, we think we're correct about this, we're just going to continue to export as if it's EAR 99. An interesting thought experiment and an interesting, quite frankly, and an interesting sort of risk balancing scenario for anybody out there who is going to be faced with a similar question perhaps at some point in the future or has in the past. How comfortable do we feel, and are we prepared to sort of deal with the consequences? Another sort of related issue that is not technically an aggravating factor is the fact that the company did also decide to take an appeal from the original CJ determination. Now, while that is not, you're never going to see that listed as an aggravating factor. I think we all know that as a practical matter, if you're going to continue to sort of fight on the underlying determination of the jurisdiction, that is something that perhaps could, whether for optics or just kind of good relations purposes, perhaps, put you in on shakier ground than if after the initial CJ, the company immediately said, okay, we understand, we accept, and we're going to move forward. Now, they took obviously some other steps that are detailed below that perhaps, sort of offset that, but that is also something to think about, and I'm sure is certainly a topic of discussion that you would want to have if you're considering whether to appeal an initial CJ determination. But at the end of the day, I think the mitigating factors that are down at the bottom here, I think tend to outweigh and in some ways, put the result of this in probably as best position as you could possibly have hoped for, given the underlying facts here. Cooperation is cited as critical at the top of the list there. And notably, of course, not a voluntary disclosure situation. The disclosure only came at a later point after the CJ determination. And as we'll talk about later, I think, and we subscribe to the view that, sort of that initial voluntary disclosure decision is certainly not the end of the story when it comes to whether or not you cooperate with the government, how you cooperate with the government, and what benefit can be gained from cooperating with the government. I think in many respects, it's sort of never too late to decide that it's in your best interest to cooperate. And here it seems that was the case, is that even though there was sort of a lot of water under the bridge already, there was a decision made to cooperate. There was an assessment and investigation that was done, and a lot of information that was furnished that obviously the government was very appreciative of. And as a result, Keysight ended up getting quite a bit of benefit from that. So I think that's something we're going to talk about a bit more. They did eventually acknowledge that the conduct and the violations through a disclosure. An open question perhaps is, at the time when the CJ gets submitted, after the government reaches out, would it have been an option? Was it considered that perhaps a protective disclosure could be provided or sent in at that point in time relating to the historical violations or the possible historical violations, even if you don't want to concede that they were violations? That's another decisional point or another sort of strategic thing to consider that relates to how to manage the disclosure. As Chris already alluded to, implementing remedial measures. I think proactive remedial measures that are taken even during the pendency of an open review or investigation are absolutely critical. We see that here. I think that has now become a very constant and consistent theme across all of the agencies in the export and sanctions area across the US government. They want to see that companies are taking this seriously and are not going to wait to be told what to do to fix a problem. They want to know that you are actively involved in looking at that problem, diagnosing that problem, understanding the root cause, and then taking affirmative measures to remediate and mitigate that problem. So that's another one that's cited here. And then the final one being a tolling agreement, which I think as a practical matter is sort of table stakes to be considered cooperative, whether it's with DDTC or any other agency at this point. If you're going to be seen as cooperative, I think you have to be willing to toll the statute of limitations, and that's just kind of a reality. So maybe let me turn to Chris for any thoughts on this before we move to the next slide.
Sure. Yeah, no, it is a very interesting thought experiment in terms of here, if Keysight had not done any further exports under the EAR while the CJ case was pending, would DDTC have gone after them nevertheless? And there's actually a consent agreement with Intercell in 2014 where that was the case. Intercell believed that the items that it manufactured were not subject to the ITAR because at the time, the US munitions list for category 15 had paragraph D as in David, where it enumerated 5 factors that made something subject to 15D as a radiation hardened component. And for their items, it didn't meet those factors. So they figured, well, if it's not enumerated on the US munitions list, we're done and we can move on to the Commerce Control List. The State Department had a different position that, well, just because it doesn't meet the enumerated criteria in 15D doesn't mean it does not satisfy the catch-all criteria in 15E as in Edward for specifically designed or modified components for items controlled within category 15, spacecraft satellites. So they thought that their items were subject to the EAR. And I believe it was in 2010, they discovered this issue from some third party that the government has a different interpretation. They met with BIS, they met with DTSA, who told them, yeah, if just because your item doesn't meet 15D, it can meet 15E. They realized what the issue was and they decided, okay, we're going to now control these items as subject to the ITAR now that we understand the government's interpretation. They also submitted a CJ request and the CJ request confirmed the government's understanding. Nevertheless, they were still subject to a consent agreement for the previous violations. So a much better optics situation for them. Nevertheless, they were still subject to a consent agreement, and I'll get into perhaps the reasons why that was the case later on. Well, I guess we'll go to the next slide because the other consent agreement I'll mention kind of dovetails with this. So this here is the first consent agreement to focus on the issue of continued exports under the EAR while a CJ request is pending. But it's not the first consent agreement to mention this issue before. That goes to the consent agreement in 2013 with Aeroflex. Aeroflex had submitted a CJ request in 2005 regarding the same issue that Intercell had regarding 15D and 15E of the USML at the time. And they submitted a CJ request, but they continued to export the item as subject to the EAR. They then got the determination that it's ITAR controlled, but they still, since they still exported the items, they still had those issues of those potential violations that occurred during the CJ request. Keysight here disclosed this, whether it appears it was more of a directed disclosure, or if it was a voluntary disclosure, the government didn't credit it as a voluntary disclosure. It's very interesting in this consent agreement that DDTC is so obscure as to what this disclosure was. But in any event, they certainly got enough credit for cooperation anyway. But anyway, from what we know from the proposed charging letter, Keysight disclosed these exports under the CJ right away. In the case of Aeroflex, they waited 4 years to do so. So the optics here still tilt somewhat more towards Keysight's way of, well, at least relative to Aeroflex, relative even perhaps to Intercell, but mostly to Aeroflex, we look good because we immediately disclosed this. We didn't wait 4 years like Aeroflex did. And the Aeroflex, even though it did have that CJ incident, there was so much going on in that proposed charging letter that it was noted, but it's the government didn't make really a broadcast of that, of those exports like it did in the Keysight consent agreement. And just mentioning this as well with the Aeroflex consent agreement, there's certainly not much that can be done when it comes to things that happen in the past. You can't go back and fix that, obviously. But when you are presented with this situation where now you're faced with a disclosure to the government, it can be very helpful to look back at other consent agreements and to get an understanding of what happened in the past so that you can kind of give a better context. And, I've obviously no idea, it's not on the proposed charging letter or anything else of what Keysight did and how they evaluated it. But certainly it would have helped build them up perhaps to show, well, at least we did disclose it right away. We know from these other consent agreements that's not always been the case. So we should at least look a little bit better in that sense. But anyway, to just return to this aspect of the consent agreement with these continued exports. So the guidance that the State Department has given is that the company has discretion to still treat the item as however they want while the CJ case is pending. But obviously with the proviso that if you are continuing to export the items while the CJ case is pending, and it comes back as Itar controlled, you're going to have possible issues with any of those exports. So just be aware of what you're going to do. So in that sense, and the language is right here on the slide on the right, I mean, in that sense, they just adhered to the language, the guidance that they already provided. You can go ahead and do this, but here are the consequences of it if this comes back as Itar controlled. So there doesn't seem to be any change to that policy. The difference here is that in the proposed charging letter, they did identify that the continued exports were an aggravating factor. So that is something to consider. These aggravating factors are discretionary. It is written into the regulations 127.12 for voluntary disclosures that if you do not voluntarily disclose, that's considered an aggravating factor. Sometimes the government makes an issue of that and will say so in a consent agreement and say there is no voluntary disclosure and we take that as an aggravating factor. Other times they'll talk about directed disclosures, but they don't say that the absence of a voluntary disclosure was aggravating. So there's still a sense here that this is, it's discretionary of whether or not the government would treat it as an aggravating factor, but they certainly have at least established this protocol that yes, we can consider this to be a aggravating factor in the future. So be mindful of what you're doing. And this does lead into the optics issues here that Brian was alluding to as well of, is this really just a case-by-case situation? If there's not these exports to China and Russia, would there have been so much of a focus here? Or are we in an area of like Intercell where there were still violations and maybe there's other factors here of why the government is going to use one of only two consent agreements that they give a year to broadcast this issue to the public and to call attention to it. So it's always difficult to assess of, why did they do this consent agreement over any other potential consent agreement that they could have done? Because in any given year, DDTC has at least a dozen, if not dozens, of situations that are all equally worthy in a sense of a consent agreement. So why at the end of the day did they pick this case? And we'll kind of explore that a little bit more later on. And it can also be helpful with, again, how to respond to compliance cases to try to maneuver them away from the pile that can lead to a consent agreement. But it is really important to just be mindful of the optics issues that Brian was alluding to previously. Because I certainly saw this when I was on the government side, that the regulators can have a certain perspective on things that industry doesn't have and vice versa. So there can be a lot of talking past one another and not realizing that certain things are an issue. Like for instance, with the CJ appeal, it's just a natural reaction if you ever lose something and you have the ability to replead your case, to go ahead and do that. But sometimes it's really important to think about it. And again, this is one of those situations where looking back at previous consent agreements and trying to see the language, see the temperature in the room with taking certain actions could have been helpful. Because once again, going back to the Aeroflex consent agreement, they appealed that CJ that they got. And the language that is used in the proposed charging letter pretty much makes it clear, you're still fighting this battle, you got to give up. And that it just, to them, it didn't look right that we already rejected these arguments. You know what the position is. We've been very clear about this. Your competitors know about this. you're just really prolonging the inevitable. And in that way, optics issues kind of also flow with government relations and government affairs. And when you are in these situations where you do have a enforcement action against you, whether it's just an initial disclosure, or you know that there is a bigger investigation, a big part of this is also just your government relations and trying to navigate this area by ensuring that you're not going to inadvertently say or do something that is going to attract more attention than you certainly want.
Yeah, and let me just, before we move on to the next slide, just a couple of, just to add on to what Chris said and to focus for a moment on that second bullet there about China and Russia. I think, this is going to come as no surprise to this group, but I think it cannot be understated how singular and important the focus is, not just at DDTC, but across all of the national security and law enforcement agencies of the US government at the moment on China. It just can't, that is not a surprise to anybody, but that cannot be understated. And so the fact that China's involved here and Russia sort of on top of that as almost icing on the cake, if you will, I think has to be considered an important factor here, because we know that, in line with what we're seeing, not just out of DDTC, but out of BIS, out of OFAC, out of CBP, and certainly out of DOJ, the focus on China is sort of far and away at the top of the priority list these days in terms of just managing and addressing and protecting U.S. national security interests. And so, and I think there's also an interesting sort of related point, which actually kind of will pivot us to the next slide, and we can go ahead and move it forward. And is, from my time at DOJ National Security Division and working with DDTC and the other agencies on these issues, I think when there was ITAR controlled technical data and software in particular that was known to have gone to China, that was of a different level of concern in some sense, in part because I think there was the feeling that, as opposed to a hardware item that perhaps has, it's one single use, that it's going to be integrated or used for, whatever its intended purpose is. When you have the technical data and the software, that is just kind of going into the pool of knowledge and tools that China may be gathering, and that one of our sort of main adversary is gathering, to be able to produce this technology on their own and perhaps produce it better than we are, or to perhaps be able to neutralize our technology in that regard. And so anytime you have tech data and software that was ITAR controlled going to China and Russia as well to a lesser degree, but I think to China certainly above all else, that was going to be seen as a particularly critical and aggravating factor, and an unusually high national security risk that goes along with that. And I know that was something certainly that we looked at DOJ, and that they still look at with respect to these cases, and that it appears to have been sort of central to the matter here with Keysight, and as Chris will go through in a moment, is sort of a theme that we see across many of the recent consent agreements as well, that factor.
Yeah, so what we want to do, since after going through Keysight, is just kind of zoom back out and look at the last 10 consent agreements. And full disclosure, these are the full consent agreements. I left out the penalty and oversight agreements back in 2015, 2016, and so forth. But what we looked at when we were just focusing on some key factors, was there a finding of harm to national security? Was there the existence of significant military equipment where there is the presumption of harm to national security? Which you can already identify here that there is SME involved in certain cases, and yet there was still ultimately no finding of harm to national security, which is good in two respects, because that shows that as a presumption, it can be overcome, but also that DDTC is taking a close look at this, and just because SME was involved doesn't necessarily mean that there is actually harm to national security, especially if those SME items were going to, say, the UK military. But also looking at whether or not there was a voluntary disclosure, the number of charges, the issue within the regulations, that was really the main issue. So we're seeing a lot of technical data and software creeping up in these disclosures or in these consent agreements. And then of course, was there a prescribed country that was involved? And then finally, just a 3-second elevator pitch of what was the main substance of the agreement. So again, we're seeing a lot of cases come up, or a lot of consent agreements where there was not the finding of harm to national security. So what then, again, they're on average only do 2 consent agreements a year. Why then focus on cases where there's no harm to national security? And that's where we come across really 3 primary areas that can lead to a consent agreement that tell DDTC, let's favor this case over another case. And that is systemic repeat issues that come up. That's number 1. Number 2, if there's really something egregious in a certain matter, that then goes to the, let's review this for a consent agreement. And the third one, which perhaps maybe was Keysight, was we want to broadcast an issue. We've seen it enough. Perhaps we missed the boat on a better vehicle for displaying that, but now we have something that we can broadcast. So we're going to use this as a vehicle, and we're going to make an example out of this company so that people can know about this issue. And that very well could have been the issue in Keysight, where it's been a while since DDTC really focused on all the consequences that exist by a misclassification. And maybe they were just in the mood to do this again. And that was the one that came up, and it had this interesting angle to it with the CJ, and maybe that was just it. But those are really the 3 buckets that we kind of see of what will lead a investigation, a disclosure case, to go from the bucket of further review to now let's consider some type of penalty or consent agreement. Next slide, please. And then here just also shows, again, more technical data being a concern. Again, a lot of cases where there's no harm to national security, and more cases where there's misclassification issues. And there's been 4 consent agreements in the last 3 years that have focused on jurisdiction classification and required a jurisdiction classification review as part of the remedial efforts in the consent agreement. And over the last 9 years, there's been 9 consent agreements. So on average, 1 a year is focused on jurisdiction classification. And the other thing too, mentioning just some issue that might be broadcast to the whole regulated community. It was on the previous slide, but for darling industries, there's kind of a unspoken rule, so to speak, about a small company that didn't really have a lot of exports, had a low profile, that they suddenly realize, oh my goodness, there's this ITAR, we need to comply with it, and we'll disclose to the government voluntarily, we'll fix this. And there's kind of this unspoken agreement within DDTC of, yeah, I mean, if a company has that type of issue, we really don't want to punish someone like that. They've uncovered the issue. As long as there's nothing really egregious, systemic about it, we'll help this company get to a good place. So it's interesting that there was nevertheless a consent agreement with a company where there's no harm to national security, no prescribed destinations, no SME. There was a voluntary disclosure, very few exports. And there they did have an interesting issue about not having a qualified empowered official. And when I was there, that was a statement that DDTC was very openly saying of their frustration that companies were not having people as empowered officials that should be, that are well-trained and know what to do and know the regulations. So that also just could have been a case of, hey, this is in our minds, this issue, and now we have a vehicle to promote it, so we can do that. So again, those are just about the 3 buckets that we've come across of how a case can move over to a consent agreement.
Let's go to the next slide. So I think this largely summarizes a lot of what Chris just kind of covered. So, why in certain cases do we tip from one category into the other? Obviously national security harm is an important factor, but not dispositive, as we just looked at in the charts. If a case is considered to be egregious, if it's a systemic or repeat violation, that would obviously up the chances that you're going to be in consent agreement territory. And then again, to the final bullet there in that top in that list, can bring public focus on an issue by enforcing the problem via a consent agreement. And so this is sort of if you look at the bottom portion of the slide, looking at that sort of hook factor, the tagline, the quick distillation of what the compliance concern or takeaway should be from a particular case, and you look at sort of the 6 most recent cases, they all kind of break down into a nice, tidy little one-line explanation as to what it is that you need to remember, if nothing else, from this particular case. And I think that, to Chris's point, this is something that, it's sort of it's in my view, it's kind of a policy-based enforcement practice. It's not just we're bringing enforcement cases for the sake of bringing them because we have the facts to do so. It's we have some broader goal in mind from a policy perspective, from a let's speak to the regulated community perspective by making a broad public statement about a certain issue that is important to us at the moment and that supports our policy goals and supports U.S. national security interests. And let's do that in a way through a consent agreement where we can really highlight that. And obviously, we will be, in the first instance, focused on deterring and remedying that conduct with the offending company. But in truth, we are looking for that sort of secondary, broader benefit, which is to really broadcast that message out wide to a much broader community, and to hope that, and frankly, from a very practical perspective, to put everybody on notice that this is something we care about, and this is something that you need to be integrating into your own program, and this is something that you need to be accounting for in administering your ITAR compliance program and your broader export controls compliance program. It is just from a sort of purely practical tool, once one of these comes out and is out in the public domain, then I think that the regulators largely think, okay, well, that's on you, the companies, and on people like Chris and I to be keeping track of these things and to be making sure that those considerations are being implemented and integrated into compliance programs at companies that need to be focused on these issues. So I think that is kind of the broader message that we see here, and this is obviously something that we see across other U.S. government agencies as well, trying to make a statement, make a message for broader deterrence and compliance reasons. And I think that consent agreements seem to be on the, in terms of DDTC's toolkit, these seem to be pretty much at the top of the list to really do that and hammer that home. So let me turn to Chris if he has any final thoughts before we move to the next slide here.
Yeah, I think perhaps a good example of that is the Intercell consent agreement, where even though Intercell actually they treated their item as subject to the EAR, and that was a misclassification, and it led to exports of ITAR items, including to China. Given the fact that they already had that consent agreement a year ago, pretty similar case with Aeroflex, why did they also go after Intercell? And there was a point that I think DDTC was trying to make, that there were some within the regulated community, and also it's in the proposed charging letter, even some within the State Department who didn't understand the issue of when there's a CJ determination, that's just saying that the item is ITAR controlled, and it's making the point that, we're not determining that something is ITAR controlled at the moment we make the CJ determination. It means that when you manufactured the item, it was ITAR controlled. So point of manufacture, and they had website guidance on this and so forth. And it is interesting. I'm completely speculating here, but they decided to go after Intercell in June of 2013 to pursue a consent agreement, which went after and discussed these larger policy issues. In March of 2013, there was a court case out of the First Circuit Court of Appeals that attacked the issue of a CJ determination, because while it's nice that the government decided that something was Itar controlled through a CJ process, it was a separate question of when it was actually subject to the Itar. Now, that was a criminal case, so there is an ex post facto issue involved under the Constitution. But nevertheless, speculation on my part, but maybe DDTC was trying to send a message in response to that court case. But certainly it's within the four corners of the proposed charging letter that, you know, they were concerned that industry also construed it this way in terms of when an item becomes subject to the ITAR, and that there were apparent concerns that even people within DDTC were confused by this as well. So they used that as a mechanism to educate the entire regulated community about it. Next slide, please. So this, we just wanted to visualize all the penalty reductions that have been imposed under the last 11 consent agreements. So there, the big blue bar is the maximum penalty that could have been imposed. The gray bar is the face value of the penalty that was issued. And then the yellow one is what the penalty was with suspending part of the penalty so that can go towards pre-consent agreement and or consent agreement remedial remediation efforts. I just want to point out that the reason why FLIR is an outlier here is because that consent agreement was in 2018, and in 2016, the fines doubled for the Arms Export Control Act. So that's why that one's a little bit out there.
Yeah, and let me just chime in before we move on that, you know, I think it's an important point, and we'll talk about this a bit more in the final two slides, but we touched on this earlier that, you know, I think obviously whether or not a disclosure is voluntary is obviously going to perhaps be cited by DDTC or by the other enforcement agencies as, you know, perhaps a positive or a negative in your column in terms of the nature of the cooperation that you've given, and in terms of capping the amount of cooperation credit that you can get with regard to penalty. I do think as a general matter, it's important to remember, and I think I will attest to the fact that certainly when I was in government, this is the way that we always sort of thought through this, and certainly this is the way that I counsel my clients on this now, is you know, the sort of whether or not your disclosure is voluntary and whether or not you are going to be entitled to, let's say, the absolute maximum amount of credit that you could possibly get is not, in my view, always the most important factor. Oftentimes, there are plenty of ways to cooperate to get yourself a lot of benefit that do not entail sort of getting maximum credit, let's say, in part because oftentimes at the early stages when violations are uncovered, you know, facts are very uncertain. You may need some time to dig in to understand what really went on, what the, you know, to try to get to hopefully at least a preliminary root cause of what may have led to the violations, to understand who was involved, what countries may have been involved, how extensive this may have been. Are we talking about a handful of violations, or are we talking about, again, systemic? Is it much broader than that? And taking a little bit of time to try to understand that before making decisions about whether to go in and disclose, I think can often be hugely beneficial and can, quite frankly, help you present the information to the government if you do decide to disclose in a much more organized, coherent manner, which they are always going to be appreciative of, and they're always going to give you credit for. So I do think that is something to consider. I am, as a former prosecutor, I am not somebody who is of the school of thought that you disclose always. That is certainly not the case. And so I think that it's a much more complex calculus to be looked at there. But I think this chart in particular sort of underscores the idea that there's plenty of cooperation credit and sort of haircutting of penalties that can occur even if you're not a company that's technically going to get full VSD credit for going in from the get-go. We can go to the next slide. And I note that we only have about 5 minutes left, so we're gonna we're going to cover these last two pretty quickly, and then I think we have a couple of questions that have come in along the way as well. So I'll turn this back to Chris.
Sure. And just quickly, the previous chart also shows that it really is the principal, not the money for DDTC. Yeah. Next slide, please. Okay. So you can read that at your leisure, and we kind of already addressed the harm determinations. Jurisdiction classification review, again, I believe it's 9 consent agreements out of the last 9 years that have focused on a requirement to do jurisdiction classification review of the items that the company manufactures or sometimes even just possesses, and certainly any item that is exported. That's a very rigorous review. It also involves not just the hardware, but software, tech data, and services. It's a really difficult requirement to satisfy under a consent agreement because there's just so many moving parts. There's a lot of regulatory interpretations that need to be provided for and really just bring everyone together. And even if there is not a jurisdiction classification review, it can indirectly come into play because a lot of consent agreements will require strengthened policies and procedures, as well as at least one audit. So what happens is you have your jurisdiction classification assessments already done. You now have new policies and procedures, and now you have an audit of your policies and procedures, which usually pertain to jurisdiction classification as well. So your previous assessments are being analyzed under policies and procedures that didn't exist. And there usually are some differences in the review and so forth and regulatory interpretations. That too can uncover issues with misclassification as well and lead to further disclosures. Aggravating, it's still the usual suspects that are involved with aggravating, but the 2 new ones here, well, I guess not new fully, but with the CJ, it's continued exports under the EAR while the CJ was pending. And also, and this was another one that came up with the L3Harris consent agreement, was that the government discovered the violations and not the company. So those are just 2 new aggravating ones. Otherwise, it's the usual suspects of lack of corporate compliance commitment, not repeat systemic violations, and so forth. Mitigating factors, cooperation, as we talked about, is a big one, and other forms of cooperation can play a key role, especially taking actions to remediate the causes for why a violation took place. And here, some companies will throw their kitchen sink at the problem. And what DDTC really likes a focus on is really doing a deep root cause analysis, what led to the violation, and really attacking it as much as you can, and with some redundancy and also some auditing so you know that it works. Because implicit from the Keysight consent agreement with, hey, the government found these issues, why didn't you find them, was, well, maybe you only had one engineer or one person look at the software. There wasn't someone else who tapped him or her on the shoulder and said, this for electronic warfare, maybe we should take another look. So it's some aspects of that, of maybe having some redundancy and auditing built into it. Next slide, please. So I think we hammered on jurisdiction classification enough, but just 2 more key points that DDTC has emphasized is just making sure you have the right expertise involved. Some cases are very simple, other cases require an engineer, so making sure you have that, as well as the documentation to support it if it's ever questioned. And sometimes jurisdiction classification falls on legal interpretations as well, so sometimes you do need a legal review. Software and technical data, intangibles, are always the most difficult of classifications, and part of the reason why is because a lot of them are caught by catch-all controls. Software and technical data directly related to a defense article. The Itar doesn't define directly related, although it does have a meaning, and the State Department doesn't realize this, but in certain places, they've actually given pretty sufficient guidance to kind of connect the pieces. But nevertheless, it's something to be aware of how are you going to define and how are you going to apply directly related. Combined jurisdiction requests, we're going to do, I believe, another webinar in the future on CJ's jurisdiction classification assessment, CJ appeals, and all that good stuff. But just there is a difference of view or perspective between the regulators and industry on how to approach CJ requests, so just be very mindful of that. CJ for the For the public, you're following the order review. Is the item on the US munitions list? The government has that review, but actually, interestingly enough, they have a second review, which is the item on the USML, and also should it be on the USML? And the standards that they apply is it equivalent to a defense article, or does it have a critical military or intelligence advantage to the United States such that it warrants control on the ITAR? And the government's not very good at discriminating which criteria it uses. And the government also spends a lot more time doing CJ reviews now. When I was there, we hit the peak of nearly 1,400 CJ reviews in 2012 with a 45-day review time and 8 people that were staffed on CJs at DDTC. Now it's 12 people staffed for about 400 CJs a year, and their review time is about 100 days. So they spend more time analyzing these cases. Agency appeals, again, maybe not the best course of action depending upon the temperature in the room, but also how to approach is a lot different than the CJ request. And then Brian, if you want to.
Yeah, we're basically at our hour, so I'll just
Yeah.
make sort of one final point here, and then for anybody who needs to drop, and I see a few people have had to leave at the end of the hour, this is being recorded. You can download to see the last couple minutes here, but we're about to wrap up. I think I'll just end on final point from me on just special situations with regard to dual or tri disclosures. We could also throw OFAC on that list as well. I think these are particularly challenging scenarios to work through, and often, obviously, if DOJ is in the mix, then you're looking at potential willful violations. You're looking at potentially criminal activity that may have, that the company or certain employees of the company may be potentially liable for, and so it just it heightens the sort of complexity here. And if for those who are familiar with the original National Security Division voluntary disclosure guidance and policy, which was issued in 2016, which I was actually still there and helped draft, and then the revised policy that was just released in late 2019. And there are 2 cases that we have that are out in the public domain that sort of were resolved under those. So Airbus came in under the original VSD program, and that's a level of complexity because not only do you have the DOJ DDTC component, but you had the DOJ fraud, UK, France component on the anti-corruption side, and then you have the recent SEP resolution, which was OFAC, BIS, and DOJ, which I think is also instructive. And I think if you have to, the questions that I ask myself and that I think I discuss with clients often is, depending on what we know about the conduct, who do we want to be kind of taking the lead on this, and are we going to be able to have any choice in that matter? Maybe there could be situations where we want to be dealing with DOJ, and you want to be dealing with my former colleagues at the National Security Division on a potential ITAR violation. And there might be other cases where perhaps the willfulness is questionable and you don't think that it rises to that level, and maybe we do want to just deal with the agency. And then you always run the risk that the agency could refer it over to DOJ, and then that you're not going to get that credit. But perhaps that's a strategic decision that you want to make there, because there are plenty of cases that involve willful or arguably willful conduct that never rise to the level of a criminal investigation. And so I think that level of complexity and nuance and thinking through who you would bring this to and when, and what the sequencing would be, and what the state of your own potential knowledge of these events is from an internal investigation standpoint is absolutely critical, and is something that you have to really think through carefully and consult both internally with external counsel and otherwise. So that's I think where I'll wrap this up. I know we have a couple of questions. I apologize we didn't get to those. We're now over time, but we will try to follow up separately with the folks who pose those questions. But with that, I'm going to wrap and thank everybody for attending. We really appreciate it. And as Chris said, I think there'll be some additional webinars in the coming months on some of the topics we touched upon here. And if anybody would like to reach out to us after the fact to follow up on anything that we covered or anything else that comes to mind, please feel free. Here's our contact info, and thanks to everybody for attending. We appreciate it.